The California Residential Purchase Agreement form is the cornerstone of every successful real estate transaction in the state of California. In this training video, we will review how to properly complete and use the RPA form step by step to better serve and protect yourself and your clients. This training is not intended to be a substitute for the advice of your broker, nor that of your attorney. We will cover paragraphs 29, 30, and 31. Our instructor for this video is Kevin Burke. Let's get started.
Let's talk about time of essence. So time of essence, it's not a typo. We all think time is of the essence, which is the long album version of time of essence. Time of essence is a legal term. And so it just simply says what it says, which is time is of the essence, which says that the time periods in your contract are going to be strictly construed. So when we have a contract and we don't have time of essence, then what happens is whenever you get around to it, it's not a big deal, right? But the problem for us is that it is a big deal. We want people to perform on time, and we're on the edge of our seats throughout a real estate transaction, making sure that we're keeping the other side's feet to the fire, right? So like if you're representing the seller, then you want to make sure the buyer removes all of their contingencies, removes their loan contingency within 21 days. Or if you establish a different time, like 10 days, then you're definitely going to be watching it and making sure that it happens. And remember, your job by agreement is to hold the parties accountable. So the sad truth of it is we suffer the lawsuit from our own clients sometimes because we didn't do what we were supposed to be doing. So when we say time of essence, we're saying it's important. We're not just kind of saying, okay, get it done by the 21st or whenever. We're saying get it done by the 21st. All right. And so we're going to talk about some definitions and things like that. We're going to get into, what time that 21st is or whatever it's going to be. So time of essence, big deal. It's not, some other time in the future. It's here it is, 17 days, 19 days. And then we get into things with each other about, when does the day fall on, when day does it end? And we need to be thinking about these things at the time that we put the agreement together, not at the time that we're in trouble. Or, it's like nobody pays attention to the contract. Nobody reads it until after it's closed. And then all of a sudden everybody's reading the contract and then everybody's a lawyer, right? So, we don't want to get into that. We want to understand it ahead of time. Okay. So time of essence simply means everybody's going to be held accountable. Time periods will be strictly construed. That is, by the way, straight out of law school, which was 25 years ago. So, okay. All right. Entire contracts. So let's talk about that. All understandings between the parties, remember parties are buyer and seller, we're in the RPA now, are incorporated in this agreement. Okay. So any understanding that we have, any agreement that we have, it's all right here. There's no coming up with something else later. You said, and one of the comments I made in yesterday's BRE conversation was, please don't tell the parties that, oh, don't worry about it. It's not, nobody enforces it. Or listen, you could be creating an illusory contract, and an illusory contract could be unenforceable. So you don't want to be doing that because your job is to create agreements between parties. And if you start telling people that, don't worry about it, they can't keep your deposit anyway, or you have 17-day free peak, that you get your money back automatically. Some of these things I just go, oh, see you in court, right? Because that's where we're going, right? And so, please don't tell your clients that. So all of the understandings between the buyer and the seller are right here. And if your buyer, you're writing this offer for your buyer, obviously you're not writing it for the seller, you're writing the offer for the buyer, you tell your buyers, or anything I'm missing? Because you know what? This is the deal right here. Did you want the refrigerator? We need to include it, okay? Those are the kinds of questions that we need to be asking now, because all of any agreements that we have made are right here. And as I had mentioned yesterday, I've had this happen recently. Just sold a property up in Idaho, and I can tell you the buyers, the listing agent meets with the buyer, meets with the seller, all at the same time. They all have a conversation. Later on, I get called in on it, and I said, okay, well, what you all agree to? Everybody knew I was involved. I'm sorry, Linda was involved. What you all agree to, and so I got I had 3 different people giving me 3 different stories of what they all agreed to. And when I wrote them all down the best I could, and I sent them to each of them, they all said, that's not what we agreed to. Okay, so that's why it's really important that you be present during any negotiations, you be present during any, because you know what? They all have another idea. I've got we have a buyer in our office right now who wants to meet with a listing agent without us, and it's like, oh, really? Okay, so anyway, what are you up to? So right, so you all know what I'm talking about, right? Okay, all right. So anyway, and of course we know we're all up to something. Okay, all right. So its terms are intended by the parties as a final, complete, and exclusive expression of their agreement with respect to subject matter. Okay, so in other words, this is it. I mean, this is a wrap. We have to put all this down right now. It is a wrap. Okay, there's not going to be any other side deals going on. And again, as I mentioned, those are the things that make us crazy, because we weren't there and we don't have any way of knowing. So that's why we like to be present for everything. And that's why we want to put everything in writing. If you put it in writing, it's very easy to say, well, this is what you signed. Okay, and so I always ask the client, I always say, is this all of it? Is there anything else? Okay, all right. And may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. We have all these rules of law, parole evidence rule, all this other kind of stuff. You know what? We're just going to take that all out of the equation right now. We're going to say, you can't contradict it. This is it. So speak now, or we're going to have a problem later, because this was the entire agreement between the parties. Okay. So now remember, at the time that you're writing the offer for the buyer, you're anticipating that the seller is also going to read this language. Okay, and so listing agents out there need to be thinking, all right, I got this contract coming to me. It's got all that language. Yeah, we don't read that. It's nothing to do with it. We don't read it, right? Well, you need to understand that your client's agreeing to it. Your client is agreeing to the fact that this is the entire agreement. And you don't have to be in this business too long to have somebody halfway through a transaction, the seller puts the skids on things and says, hey, you know what? Wait a minute. I ain't giving you the dining room table, right? That's been in my family for 12,000 years, and so now it's a really big deal. Except you agreed to it in the contract. Well, yeah, but I didn't read the contract. Well, boy, that's a really bad defense in court. Okay, all right, really bad defense. Okay, all right. If any provision of this agreement is held to be ineffective or invalid, so if it's held to be, it isn't not enforceable, whatever, the remaining provisions will nevertheless be given full force and effect. Okay, so that's a really important point. If paragraph number 28 is held to be invalid by a court, whatever, we saw happen recently in our independent contractor agreement, well, about 5 years ago now. Our independent contractor agreement, they held that the arbitration clause wasn't valid. That went way up the chain in the legal system, and finally came back and said, we had to change our form, okay, because the form wasn't right, okay? And you all are experiencing that now anyway, twice a year. You're experiencing changes to the forms that are a result of some of these things, okay? So some of these paragraphs are not surviving constitutional muster. They're not, surviving in court, things like that. And so then we come back and we go, oh, okay, well, then maybe we need to change those things. Hi, Daniel. Does the escrow instructions supersede the original signed contract, even though they should be the same? That is a really good question. It is one of the reasons why we changed our agreement between the parties. It used to be residential purchase agreement and receipt for deposit. And then in October of 12, we changed it to residential purchase agreement and joint escrow instructions. And part of the reason was because we would send our contract, by fax, right? By fax to the escrow company. The escrow company would rewrite, rewrite our document, send it back to us and say, is this okay? And then we would look at it and we go, well, I just wrote it. It must be okay. But the problem is that escrow didn't write it. You did, and now you didn't review it or whatever. And so here's the answer to your question is, it's going to depend, okay? And that's why that makes me really nervous, okay? Because it is the after signed thing. So in other words, the purchase agreement is the contract between the parties. And we've said now that it is the contract between the parties, and we've handled language about that says that, as does this. Okay, so we're going to get to that in a minute. You're going to see it in the bold print. But when escrow comes along and drafts an escrow instruction, most of their escrow instructions are general provisions, please don't sue us, things like that. They are not intended to be a contract between the parties. And the mistakes, I should say that again, they are not intended to be a contract between the parties. They are an instruction, an amendment to an instruction to the escrow company. They are not an amendment to the contract. Okay, remember, addenda add to things, amendments change things. So when the real estate agent calls up the escrow company and says, why don't you draft an amendment that does this and this and this, right? And escrow goes, okay, sure, we'll do it. And they draft it up and they send it around to everybody and they pray the other side's going to sign it because they didn't have their instructions to do it, whatever. That doesn't change the contract. And then the escrow company mistakenly puts in their escrow instructions, this is intended to amend the contract between the parties. Now, guess what? Now we're gonna have a fight. Okay, it's gonna be a big fight. All right, I won't work with an escrow company that does that, because at the end of the day, their job is to follow my instruction. Their job is not to create a contract between the parties. So when there is an amendment to something, when everybody agrees to do something like a request for repair or something like that, or an extension of escrow, those kind of things, you and I need to prepare that. This is a very important principle of law. We need to prepare that instruction to escrow, not escrow prepare it to us. Okay. Now, sometimes they write really cute language and all that kind of stuff. Don't be distracted by that. The idea is that you need to create the contract between the parties, and we're going to see in a second why you need to also make all changes to the contract, because exactly what you're asking, if there's going to be a dispute, it's going to be because, well, here's the contract I signed, but later on, the after signed document, later on, here I have this other document that says something different, and I like that better because that one says what I want it to say. I changed my mind on what I signed in the contract, and now there's a fight. So, Daniel, your question's a really good one. Do the escrow instructions supersede the original signed contract? I'm going to tell you, I can't give you legal advice. Probably not, but it's still going to create a fight. Okay? All right. Okay. I say probably not. Y'all know what I'm saying. Okay? All right. Okay. Great question, though. Okay. So, so except as otherwise, oh, you know what? What did I do with my pen? Oh, gosh. I got carpeting, so now I can't find any of my stuff. So except as otherwise specified, this agreement shall be interpreted and disputes shall be resolved in accordance with the laws of the state of California. We've got to say that, right? The buyer's coming from New Jersey. They want the rules and the laws of New Jersey. I just had a lawsuit where the buyer came in from New York and they came into Orange County Court, and I'm in trial in the Orange County Court, and they go, well, that's not the way we do it in New York. Oh my God, I'm glad the contract said what it says, which was this laws of the state of California will be our choice of venue for one thing. It will also be the laws that we're going to follow. Can you imagine? And they thought, and you know what was worse? They were a real estate agent in New York. Okay. Didn't bother to tell anybody that, but okay. All right. So bottom line was they were not successful at trial. Okay. Let's just put it that way. Okay. So another one. All right. Not bragging, but it's like, look, you got to read the contract. Okay. All right. Okay. So let's take a look. Shall be interpreted and disputes shall be resolved in accordance with the laws of the state of California. Now, Daniel, to answer your question, neither, bold print, neither this agreement nor any provision in it may be extended, amended, modified, altered, changed. Call it anything you want to call it, right? Okay. It's like the commissioner say, all fees received by the broker, we're going to call them commissions, right? Because we don't care about all that other stuff. We're just going to call it one thing. So guess what we're going after? So at the end of the day, you can call it anything you want to call it. If you're going to do anything, it must be in writing, signed by the buyer and the seller. And of course, you all remember your conversation on the statute of fraud. Statute of fraud says an interest in land, in order to be enforceable, must be in writing. The law in California says that, you know what, you can buy and sell property all day long with a handshake. God, I wish it was still that way. Back in the 70s, and I'll give you copies of the one-page purchase agreement that I was using, but years and years ago, back in the 70s, we pretty much was a handshake. We just did the contract so that, everybody was, have an agreement to sign, right? Today, I wouldn't do that on a bet. But at the end of the day, you can have anything you want to have between the parties. The problem is it's just not enforceable, right? So if the buyer takes the seller into trial and says, well, we agreed to do this, and the judge is going to look at you and go, hey, fine, not a problem, I'm in. Okay, show me your paperwork. And then you go, well, we shook hands on it. We put dirt in each other, seasoning, right? We put dirt in each other's hands, transferring title one to the other, and the judge is going to look at you like you're nuts, right? So at the end of the day, it has to be in writing, okay? Otherwise, It's unenforceable. So you can do it. You can go ahead and do it. I think your broker would have a problem with that, right? Check with your broker. But if you go ahead and you create something that an agreement between the parties that is on a handshake, based on a handshake, you're a better guy than I am. And I can tell you, I get it. There's always somebody that comes back, some wheeler dealer says, I do these deals all the time. I'm doing land. I just closed a land deal. Listen, I'm glad we did it in writing. Okay. So, land, I do this, we do that, business ops, right? Biz ops, we're doing exchanges about that kind of stuff. Listen, everything is fine until one day. Okay. And I had a broker call me, she said, a good broker too, I just love her, but she calls me up and says, I'm being sued. I can't believe it. And I said, what do you mean? She says, well, I've been doing it this way for 30 years. And I said, oh no, you've been doing it wrong for 30 years. Okay. So, well, lawyer up. We're going to have to defend, or you're going to have to defend. I'm not. So bottom line is, don't just, every once in a while you need to do a self-assessment. Okay. Would you all agree with me? Please do a self-assessment every once in a while. Make sure that you're up to speed on what is going on. Make sure that you're not just assuming things that have been working okay for a while, and so they must be okay. And that's not the way to do real estate, right? And remember, the rules change. So here's my addendum form, and the addendum form very specifically. So what did that language say that we had a minute ago? If you're going to make any changes and that kind of stuff, it has to be in writing. So here's my addendum. Okay, so my addendum, I'm going to name it number 1, whatever. Okay, we just revised it 12 of 15, and the reason that we revised it was we added in the transfer disclosure statement. Oh God, about time, right? Okay, so what does it say? Now, we talked about this yesterday, and I sent a really good Q&A into SDAR to send around to everybody regarding why it is so important to fill in the top part of the contract properly, check the right boxes, because everything I do from there forward is gonna rely on that original document. And the addendum is just like that. Counteroffers, if I don't check the box and put in, and I see it's done all the time where the agent doesn't put in counteroffer number 1, they don't even check a box, they just write a counteroffer, and it's like, well, how do I know what that goes to? And so, when we go to court, which is usually 2 years and 9 months from when the transaction closed or not, then you know what? Now all of a sudden your memory's not so good. All right, so we want to look at our addendum, for example. This is made a part of the purchase agreement, or the residential lease or month-to-month rental agreement, or the transfer disclosure statement. Oh boy, watch out. It may give the buyer the right to rescind. I'm going to be doing a class on Monday for a pretty good sized brokerage on disclosures. So if you want another class on disclosures, would you send an email to education@sdar.com? Because listen, I think that's something we haven't done in about 3 or 4 months. I did a really good one that was on, and it's dropped off the queue, but TDS, SPQ, SPQA, and your Avid. And you know what? Those are the zingers. I'm going to add 2 at the natural hazard disclosure. So I'm going to have 5 must-dos in a real estate transaction. So anyway, okay. So TDS, and then others. So you need to specify what it is, because remember, I need linking from one document to the next. So I need linking from my purchase agreement to this document. So that's why this information has to be in there. What was the date of the purchase agreement? Okay, all right. So those are, and who are the parties? Those are the important things. So in other words, I'm going to use this form anytime that I want to amend an instruction between the parties. Okay, I'm watching my internet slowing down again. I have brand new generation 6 internet. Okay, so accept in writing, signed by the buyer and the seller. You can all see that on the screen, I hope. I'm just going to double check, and it says yes, you can. Okay, so all signed by the buyer and the seller. So we want to do that. By the way, I see this form used, strangely enough, I see people essentially what I think is legal advice, but watch this. When I take a look at this form, look who the parties are at the bottom of the form. This is the addendum, okay? So at the bottom of the addendum form, who signs the addendum? The buyer, the seller, the tenant, the landlord. Does anybody see agent in there? There's no agent in there. This is because the contract is not between you and the parties. And this form was designed specifically to exclude us as agents. And here's the problem that I see. A lot of times I see agents crossing off buyer tenant, putting their name. They made an agreement with the seller to amend the contract. You need to use a different form than this, folks, modification of terms. So make sure you're using the right form for right things. This is the proper form to change the contract between the parties. This is not the form to be filled out by the escrow company. Okay, Daniel, question, excellent. It was a 400 level question. I'm filling this out. I'm going to have the party sign it, and I'll send it to escrow, and I'm going to say, here's your instruction. This is what we want you to do, not will you do this. Okay. All right, good question. Okay, so I'm going to grab a new share again. If it's going to cooperate, here we go. Okay, back to my agreement. Any other questions on our first paragraph? I know. It's, okay, wait till we get to the second paragraph. They always got to really get good. Okay, so I clicked on next. I'm going to grab a little bit of my afternoon tea. Let's talk about some definitions. Some of these in here are going to surprise you. All right, so let's take a look at these. Okay, so first of my definitions is acceptance. And again, I always, the calls I get on the phone, and I'm always happy to help folks. I'm not making fun of anybody. Please don't take it that way. It's interesting to me because a lot of times I'll say, well, what does paragraph number 30 say? And I'll go, huh? And I'll go specifically paragraph number 30, number F. Okay, so unfortunately I talk that way because that's just, for me, it's comedy. But let's take a look at this. Acceptance means the time the offer or final counter offer, okay, is accepted in writing by a party and is delivered to and personally received by the other party or that party's authorized agent. What do we call that? We call that delivery, right? We're going to talk about delivery again. So when was acceptance? When do the time periods begin? Time periods begin at the time the offer or final counter offer is accepted in writing and is delivered personally to the other party, okay? All right, okay. So now we know what acceptance means. All right. So conversation always comes up. Okay. Well, what happened? Buyer and seller. So the seller signed the buyer's offer. They signed it on Sunday, but they didn't tell the buyer about it until Monday. When is the date of seller's acceptance? Well, Sunday's the date of seller's acceptance, but the buyer didn't know about it until Monday. If I was the buyer, I'd be arguing that my time periods begin on Monday. Now, why would the seller not give it to the buyer on Sunday when they first got it? Okay, sometimes the seller's holding out for another offer to come in, things like that. Hey, that's on you. You have to have delivery back to the party to be bound. Otherwise, there's no meeting of the minds. Okay, all right. Paragraph number B. Agreement means this document and any counteroffers and any incorporated addenda collectively forming the binding agreement between the parties. So what we just said a second ago in paragraph number 29, the whole group of things, okay? Addenda are incorporated only when signed by all the parties, all right? So remember, that if the buyer says, I want the lawn furniture and the seller doesn't sign it, then it's not part of the contract, okay? This will be a question. I got a question here. It'll be a question about closing. Okay, Gabrielle, what if the seller signs the counter but doesn't sign the RPA? Oh, another 400 level question. You all are so good. Okay, so let me tell you something. Anytime a seller's agent, the listing agent, sends you back a counter offer, the response is always, please send me also the seller's signature on the original offer. Okay, I don't care about the initials except paragraph 21 and 22, right? Liquidated damages arbitration, but please send back the contract, right? Folks, I've had it happen. Listen, I learned this the hard way where the seller had never seen the contract. Okay, the agent drafted the contract. I had a lawyer, and he's a big lawyer, and he's not in our association, he's in another association, send me a 4-page letter on why we couldn't hold their seller to the contract that they never saw, even though we had agreed to the counteroffer and moved forward, done inspections, done things like that. A 4-page letter, folks, let me tell you something. Any lawyer, there's a joke in law school, any lawyer that can't say it in a page doesn't know what they're talking about or is just giving you a bunch of crap, okay? I got a 4-page letter. I had it bronzed. I love it. Okay. So the answer to your question is, what if the seller signs the counter but doesn't sign the RPA? I want it back now. okay, until a few days later. I know it's not proper, but lazy agents do it all the time. When is acceptance? Acceptance is when you have delivery. So now the counteroffer form says that if you've got the counteroffer signed by all the parties, then the assumption is that they agreed to the purchase agreement as written, okay? Again, you're asking a really good question. Let's get that offer back right away. I'm going to tell the other agent, I'm assuming we don't have a deal. It's going to depend. I got to talk to my client about that. But, I'm going to assume that, that there might be a change been made. And I've had it happen where, you get that offer back and the offer's got, strikeouts and stuff like that on it. And it's like, well, wait a minute, then we don't have a contract, right? Any modification, remember my principle of counter signatures, look up to the light test, and if something's been altered, it's not going to work, okay? Carolyn, in regards to expiration of the offer, if the buyer signs agreement at 11:30 p.m. on, is this a later question? No. 11:31 p.m. on 7/21 is not delivered to the seller until 7/22. I'm going to tell you no contract till 7/22. When does the offer expire? Is it 5 p.m.? I don't think I have all the question there, Carolyn. If the buyer signs the agreement at 11:30 p.m. on 7/21 and is not delivered until 7/22, when does the offer expire? I don't know. I don't know what I don't know what the dates are in the contract. Did I say something earlier that you're trying to expound on? Is it 5 p.m. on 7/24 or 7/25? So it'll be whatever the contract says. So when the buyer writes their offer, they put in a time for acceptance. And if the seller, and that'll be the date and the time, and that is specifically why we put that in the contract, because we want to know the date and the time that the seller has to respond, or depending if it's a counter offer, the buyer has to respond in order to create a contract between the parties. So the problem here again is that I might get into an argument over when was it accepted. So if in fact the seller signs it at 11:30 p.m. on 7/21 but doesn't give it back to the if the buyer signs the agreement at 7:20 and it's not delivered to the seller until the next day, well, the way I write my offer, listen, I don't give them that much time anyway, so I'm not going to do it. I'm not sure if I'm answering your question, but it looks like you might have a little. I've had attorneys look at this and tell me I don't have a contract if the buyer didn't sign the RPA. Oh God, that's new. The buyer didn't even sign the RPA. He said the buyer signs the agreement. Therefore, how can we have acceptance and not a contract? Well, yeah, there's got to be a contract, and there has to be a common. There has to be a common theme. There has to be meeting of the minds. So you meant to say don't have a contract if the seller didn't sign the RPA, and that's the argument. The argument is, do I even have a contract? I mean, if all I got is a counteroffer and I don't have the RPA, the school of thought says that I may not even have a contract. Okay, so for me, I'm going to argue on behalf of my client. If I can get everybody to cooperate and move forward with it, then okay, right? We're going to call that ratification. There's some principles of law that says, okay, if I can get everybody ultimately to sign everything, but you know what? If they never deliver it, I don't think I have a deal. I just don't, and I'm going to counsel my buyer not to move forward and pay for stuff if they don't have a contract. Okay. All right, and especially because there are clauses in the contract that allow the buyer to come into the property, do inspections, and do things like that. But without those clauses, their status changes from invitee to guest, and it's like different principles of law affect slip and falls and things like that. So it's one of those things where it's really twisty, and it can get really ugly for us. And our E&O doesn't cover that. So your question, if I'm understanding, is a really good one. If they don't sign the agreement, or if they miss the timeline, if for example they go past the timeline, then the buyer doesn't have to accept it. The buyer can say, "Oh, I'm done. You missed the timeline. You can't commit me to the contract, and I'm not going to do it." Okay. Gabrielle, I think I'm answering your question, but if not, let me know or send me an email, and I'll be happy to pick it up on the other side here. Okay, all right, agreement, CAR form means the most, now this is important, the most current version of the specific form, okay, all right, the most current version. So I just had this happen with an agent that wrote an offer on a property and used an old contract. Actually, I had one even better story. I had one where, it's probably about 10 years ago, and it was written on a CAR form from like 1992. And I asked the agent, I said, "Where did you get this?" He says, "It's in the trunk of my car." And I said, "Write a lot of offers, do you?" And he goes, "No, how'd you know?" Man, you should have had that bronze, dude. I mean, the 1992. So anyway, I'm going to have you rewrite the contract, okay? Because I don't have the protection. My client won't be protected. Not because I'm being a jerk, but because I want to make sure my client is protected by the language that's included in the agreement. Right? Okay. So happens all the time. Make sure you're using the current RPA. You don't have to worry about us revising the RPA until next year, right? December of next year, 2021, where we'll have the revisions done. We'll be doing training classes at SDR long before that. Okay. But you know what? We absolutely have revised the listing agreement. Okay. So that has already happened. So make sure you're using the current listing agreement in your transactions with your seller to protect your seller and then to protect ultimately the buyer downstream. Okay. All right. Close of escrow include, so most current version, including COE. I always love that. I had a judge in court once, and the judge says, "What does COE mean?" And I went, "Oh, wow. I mean, here we are all running around. Everybody thinks, we think that everybody understands our language, right? And it's like, we talking weird things. COE +3. I mean, what the hell does that mean? Sorry, pardon my language. But, at the end of the day, don't talk in terms of TLAs, 3-letter acronyms. Talk in terms, use the Queen's English, okay? So close of escrow, don't say COE, means the date, the grant deed or other evidence of transfer of title is recorded. So you and I here in California, we use the word close of escrow. In Virginia, we use the word settlement. In the legal field, we say transfer of title from seller to buyer. And that is the true part about it. So for example, last night we closed a transaction, it closed special. Special is really normal, right? They're all closing special anymore. And so, the question was, do I give the buyer the keys? And it was our listing. And the answer was, does the buyer own the property? And of course, the response was, I don't know. And I said, well, did you hear from escrow title, somebody telling you that, congratulations, we have confirmation. We call it confirmation, right? If you don't have that, folks, and you turn over the keys, we're going to have problems, okay? I had this happen personally where I go to one of the houses I had just sold and the other broker had handed the keys over to the buyer before closing. And I'm at the house before closing picking up some personal things, and they're halfway through the remodel, okay? And guess what? There's a lot of praying going on at that point. I couldn't believe it. This broker had been around a long time, and I love her dearly. But she said, I thought it was over. It ain't over. You have to have that confirmation, okay? So close of escrow, very important. Grant deed, other evidence of title. Copy means copy by any means. Photocopy, NCR, remember National Cash Register, facsimile, anybody using that anymore, and electronic. So in whatever means it is, if it's a copy, if it's legible, we have a saying at law called the laugh test. The laugh test is when the judge is looking at your fax document that's been faxed 8 times and it's just a smudge, and he looks at it, he says, you want me to enforce this? He starts laughing. That's not a good day, okay? That's a bad day. All right, days means calendar days. Write that down. Days means calendar days. This is like the number one question that I get. How many days? Well, calendar or business. So what do the contracts say? Well, the contract said business days. Well, then it's business days. Or what do the contracts say? Well, it doesn't say anything. Okay, so then if it doesn't say anything, then it's calendar days. Okay, so one of my dates, so from date of seller's acceptance, day number 1 is the date after notice delivery to the party to be bound, right? I'm going to argue I don't have a contract until I get all that, and I want my contract. Gabriel, your question, good question. I want the contract, and I'm entitled to it, okay? Not just a counteroffer. Okay, days after, I'm sorry, wait a minute, hold, days means calendar days. However, I have 2 screens going here, so I apologize. However, after acceptance, the last day for performance of any act required by this agreement, including closing, shall not include Saturday, Sunday, or legal holiday. How are you going to close on a Saturday, Sunday, or legal holiday? But better yet, you're not held to perform on that day. What does it say? And shall instead be the next day. So I sent an email to Neil Kalen. I have a lot of respect for Neil. He's one of the CAR staff attorneys, and he wrote me back a really great response. I said, how come that says next day and doesn't say the next business day? And you know what? It was actually addressed by legislation. So it was pages long, and the guy is I just think he's gifted, right? And he just writes this Great thing. I printed it. I said, can I copy this? I mean, I'm not going to, I'll give you credit. He said, I don't care about credit. I said, I'm not sending it without giving credit, right? Because it looks like I wrote it, and then that may be plagiarism, might be legal advice. So, but at the end of the day, listen, it was great. But the answer is that days means calendar days. If the date for performance falls on a Saturday, Sunday, holiday, then it shall be the next day. So folks, watch your closing date. If you put your closing date being Friday, May the 29th, right, and it doesn't close on the 29th, something happens, the lender funds on the 29th, but it doesn't record until Tuesday because Monday was a holiday, right? Your buyer just paid for Friday, Saturday, Sunday, Monday, and Tuesday prepaids, right? Paid interest, paid all those things for those days. They're coming after it, all right? They want somebody else to pay it. How come I funded on Friday, but I can't have the keys until Tuesday? Okay, so watch those days. And remember, this is different than the old contracts from years ago that used to say, shall close on or before, okay? We didn't like on or before because it was vague and ambiguous. You know, it was set up to close on the 29th. Buyer calls in and says, I'm closing on the 14th, you know, and the seller says that's 2 weeks early. We're not going to do that. So then we got to fight, right? So we wanted to create something that says time of essence, right, John? Remember, time of essence, nailing it down. And now if it's Friday, then it's Friday. But guess what? I'm not handing over the keys until title transfers from one party to the other, okay? All right, okay. Very important provision. Paragraph number G, days after, means the specified number of calendar days after the occurrence of the event specified, not counting the calendar date on which the specified event occurs and ending at 11:59 on the final day. And I think that's going to answer somebody's question in here from earlier. So here's the thing. So how do I count my days? So if acceptance is Monday, then day 1 is Tuesday, day 2 is Wednesday, day 3 is Thursday, day 4 is Friday. Everybody follow me? The next day can't be the same day, right? Because you're not getting a day out of it. You're not getting 24 hours out of it. So it's the next day, okay? And then, of course, you know, I'm clocking my 17 days and it ends up the 17th day is on a Sunday. Then I go back into paragraph number F that says it shall be now Monday or Tuesday if Monday's a holiday. Everybody good? It's important, okay? Because when you get questioned on it and you're on the spot, now you know the answer. So you are all good because you got the answer versus the 20,000 others that don't bother to come to the class. Well, we have almost 1,000 here today, so 19,000 others. Okay, all right, so paragraph number H, days prior means you don't see a lot of that. It means the specified number of calendar days before the event, not counting the calendar date on which the specified event is scheduled to occur. So days prior, for example, you may send the notice to buyer to perform no sooner than 2 days prior to the date that it runs. So if the date for performance is 17 days, then you may not send it before the 15th day. So counting backwards, not counting the 1 day, I've got 2 days and I've got the 15th. So on the 15th, I send the buyer's notice to buyer to perform, and the buyer has now until the 17th. And then on the 18th, the seller has the right to issue cancellation instructions. That's all the notice to perform does, is tell the other party of the first party's right to cancel. That's all. Okay, they don't have to cancel, it just means they have a right to. Okay, thank you for my tea. All right, delivery, unless otherwise specified in writing, means and shall be effective upon, where is it? Okay, upon personal receipt by the buyer or seller, personal receipt, okay, or, or the individual real estate licensee for that principal, if you put your name in it, right? If you put your name up there at the top, at the bottom of page 9 that says, you know, delivery can be to you, then delivery to you creates a contract. I have a hard time with that because I don't want to be a party to the contract, but I might be making myself one because, and yeah, I agree, I am the agent for the client, but you know what? I want my client to make the decision they still want to buy this place, okay, or still want to sell it, okay? All right, so for that principle, as specified in the section titled Real Estate Brokers on page 10, as we said down, the broker box, we call it on page 10, regardless of the method used, whether it's messenger, mail, email, fax, other. By the way, there's this other rule of law that says counteroffers are subject to what's referred to as the Mailbox Rule, which means the buyer writes their offer. There's no delivery until it gets back to the seller or gets back the seller's acceptance. I'm sorry, back up. Okay, it gets to the seller. The seller signs acceptance and counters. Now the Mailbox Rule falls into place. It is considered received by the buyer the day the seller puts it in a mailbox. I don't think you probably have a lot of those. I hope not, but and I don't know a whole lot of lawyers that really think about that, but it's a rule. You can Google it, Mailbox Rule. Okay, all right. Some of the stuff I actually read in law school. Electronic copy or electronic signature means, as applicable, an electronic copy or signature complying with California law. And mind you, we're working on electronic signature for notaries now too, and that's been a debate for a long time nationally, actually. Buyer and seller agree electronic means will not be used by either party to modify or alter the content or integrity of the agreement without the knowledge and consent of the other party. Because you know what? Sometimes, folks, we got really good software, and I've been asked to come into court to testify as to whether or not, what was the date that the signature actually happened. Was it the date? Was it the electronic signature with the electronic date, or oh no, it turns out that somebody had manually put the date in by double clicking on the zip forms, and it popped in the date that they wanted it to say. Okay, all right. So let's not do that. And please don't alter documents. I mean, I know we're really smart people, but somebody asked me the question yesterday about if the listing agent makes a mistake in the counteroffer that they send over to the buyer, and you're the buyer's agent, can you just fix the mistake? And the answer is that might be forgery, right? Because you're changing something above a signature. I can't tell you it's forgery, that would be legal advice, but you're changing something above a signature. And I think that you might not be able to do that, or I think you should not do that, okay? All right. Okay, law means any law, code, statute, ordinance, regulation, you call it what you want. It's like the real estate. People think that there's this the Department of Real Estate issues laws. They don't. They issue regulations that have the full force and effect of law. I would listen very carefully to what they tell you to do, right? But anything you call it, which is adopted by a controlling city, county, state, or federal legislative, blah, 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 that's going to be the law. So you can call it a regulation. DRE issues regulations. I think it's a law. I'm going to follow it like it is, okay? Even though it really is, by law, it's really a regulation, okay? By contract, we're saying we don't care. We're just going to call it all a law, okay? All right. Repairs means any repairs, including pest control. Remember, no termite, okay? Pest control, alterations, replacements, modifications, or retrofitting the property provided for under this agreement. So any repairs that you're going to do, this is the bucket, okay? All right. Signed means either a handwritten or electronic signature on an original document, copy, or any counterpart. Okay, so we covered counterparts again. Hold it up to the light test. Same document twice, just the signatures on different pages. It's a contract. Everybody good? Questions? Tell you everybody. Oh my God. Seller for counteroffer. Great, thanks. Uh-oh. What did I say that was great? I say so few things that are great. Anonymous, tell me, what did I say that was great? Laura, were you going to quickly go through completing an RPA from start to finish, or is there more explaining terminology of RPA? I'm not sure what you mean. So do you want me to do the RPA from scratch? We don't have time for that today. Completing an RPA from start to finish. Or is this more explaining? Right now, we're talking about paragraph number 30. Yeah, exactly. We're talking about paragraph number 30. Laura, catch up with me because I think I'm missing something. But I can get you access to all of the things that we've been doing with this RPA, and it's been really, I think, really good stuff. And one of the things that I've talked about SDAR, one of the unique things that SDAR has done, has given us the ability to have these live. And the reason that is so important, and I teach my classes, I'm going crazy right now because I'm teaching at UCSD, continuing ed for attorneys, and it just pains me that I can't interact with a student because, we're not doing classrooms, right? And so it just really causes a lot of problems for me mentally, like I need more help. But, at the end of the day, we have a lot of really good material out there, but I prefer the interactive in the class kind of thing, and I'm really kind of looking forward to when we can start doing that again. But as far as going through the RPA from start to finish, we're not gonna be able to do that today. We don't have enough time, but I'm more than happy to do it with you. I love the RPA. In fact, people call me up and they say, can you just give me the hot points? So Laura, I don't know what office you're with. Would you send an email to SDAR and ask them to have me come do a quick overview? I just did one, a quick overview of the RPA. I did it for another broker last week, in fact, and we just did an RPA. Here are the things I'm looking for. Boom, boom, boom. This is where we get in trouble. These are my lawsuits. These are what I look at. But your question is a really good one, and it applies to anybody here. If you have a question, if you want me to come talk to your office, please send an email to education@sdar.com. I would love to do it. I really do, because it's the interaction that we have that beats the, I'm speaking to a machine when I'm, doing the university classes, making me crazy. And of course, they're lawyers and paralegals, but you know what? I'd rather talk to you. So anyway, thank you for that, Laura. Laura, please. Yeah, absolutely. I'd love to help you with that. I'll try to remember. I'll look you back up, or send me an email, copy me, send an email to education@SDAR and say, hey, can you come to my brokerage and do a class on the RPA? I'll tell you where the suits are. Give me a TDS. I'll tell you where the lawsuits are in the TDS. You'd be surprised. Okay, anyway, personal experience. Nadine, do you often send notice to perform 2 days before specified? Absolutely, I do. Count on it, okay? It's not intended to offend the other party. It is just intended to provide notice, because I have to, by my agreement with my buyer, I have a buyer representation agreement. My seller, I have a listing agreement that says that I will be a professional, and I will send those things ahead of time, because they can't cancel by contract. They can't cancel until it's sent. And I'm the guy that has access to the forms. Everybody's going to be looking at me and says, well, hey, Kev, how come you didn't send the notice to buyer to perform? Or how come you didn't send the notice to seller to perform? And I can't say, well, it's your job to sign it, because then the seller is going to say, yeah, I know, but I didn't have it to sign. I didn't even know what it was. And so it's my job to provide those forms. Okay. So again, we do risk management. We have a great lawsuit avoidance class that we do. In fact, I think I've got it coming up again. Is it next week or the week after? We'll be doing lawsuit avoidance again. And every time we do that class, I change it. So it's like just something's happened in the last month that, is going to be important. Okay. Nadine. So, or do you send on a case-by-case basis? No, no, it's a matter of principle. Or whether the other side seems to be dragging their feet. No, Nadine, good question. So in the beginning, when we first came out with the notice to perform, people were having like a heart attack. Oh my God, I wouldn't send one of those. It'll just upset the other side. No, I have to. I'm not worried about upsetting the other side. I'm worried about my client suing me, okay? My own client, all right? And I say that, but you know what? At the end of the day, everybody would take offense. They would go, oh my God, I can't believe you sent me the notice to perform. But now, people have settled in. I remember when it first came out, because I remember I was proofing it, and there were spelling errors on it, and it said seller instead of buyer. And it's like, oh, but I'm telling you something, it's your job. So don't worry about sending it. It is your job. You will look professional to your client, whether it's the seller or the buyer, at the same time that the other side should be professional enough to know, I get it. It's just a matter, of course, of doing business. Okay, that's all. Remember, when you send a notice to perform, it doesn't say that the other party's canceling. It just says that we're just reminding you that they have a right to cancel. Okay. James, can you send blind offers? What's a blind offer? Is that one when I write it like this? That's ADA compliant. Okay. If so, what language do you use to make it contingent on viewing where you put it? Oh, are you saying, I think you're saying, do I write offers for clients who haven't seen property? And the answer is, yeah. I don't know what blind offer means, but did I get it right? Okay. So you know what? I have it happen all the time. I've got a renter moving into a property in La Jolla that hasn't seen it. And because of COVID-19, they didn't want to see it. They're coming from a city that is going to quarantine them if they come out here to California and look at the property. When they go back, they're quarantined for 14 days, which means they have no income for 14 days. So you know what? Our current tenant, God love her, she wandered around the place with a video and said, here's what you're getting. And they said, we'll take it. Okay. So I don't know about blind offers. I had a property I just sold up on Palomar Mountain. I don't think the buyer ever saw it. Yeah, sure. I don't have a problem with that. But here's a good point. And remember, I've been teaching the law class for over 20 years now, almost 20 years. And I tell them, pretend like your client is coming from Pennsylvania. So when you write the offer, or when you do a transaction with someone that you're working with maybe for the first time, assume they have no idea what goes on in California. Just like the story I told a minute ago, where the New York real estate agent assumed that the laws of New York applied in California, in Orange County, right? Good luck. Okay. So Great question. Assume your client's never seen it. When I do the Amityville case, the Amityville case was a real case. It really happened. Okay, now Hollywood made it out to be a lot more than it really was, but at the end of the day, the Amityville case was a real case. Look it up. I mean, it's crazy. And it all had to do with a buyer buying a property in an area that they weren't familiar with. And the whole town knew that this property was haunted and you know, whatever that means. I don't know what haunted means, but it was haunted. And this buyer bought it, and the court did that very rare unwinding of the deed. They actually made the seller buy the house back. That was a weird case, okay? You never see it happen. It'll be just on my watch that it will. Thank you for going. Oh, did I go over? Thank you for going over. I honestly had never even considered sending before the due date. Oh, okay. Thank you, Nadine. Okay, so you mean, I thought I was over on time already. I don't know, I got a couple minutes left. So, yeah, don't wait, because whenever you send it, they've got 2 days, right? And so, or 3, whatever. Our purchase agreement actually has 3 in it. We put 3 days in there. Nobody ever reads it, so we end up with 3 days, right? But listen, don't wait. I mean, if you send it on the 17th day, the contingency is to be removed on the 17th day, and you send it on the 17th day, they got 19 days. I'm sorry, they got 2 more days to perform. They have until the 19th, right? Or in our contract, you know, the 20th. Okay, but you just may not send it sooner than 2 days before the time period runs. That's all. So when we go back, you know, you'll have to go backwards here and look at that notice to perform, notice to seller to perform, notice to buyer to perform. Originally, we only had a notice to buyer to perform. We never really thought about the fact that the seller wouldn't perform. Well, I think sellers don't perform all the time. Okay, but you know, absolutely, you just may not send it any sooner than 2 days prior to the time period running. So you can't send it on day 14 with a 17-day contingency. Okay. But on the 15th day, hey, it's going out. Linda keeps track of this. In our office, we do all their transactions for them. So, you know, we just send it out. In fact, you know, one of my agents, I love her to death. She's great. And we sent out the notice to the buyer to perform without telling her. We just did it. And it was her first transaction with us. And she's like, God, I wish I had known you were going to send that, because I guess it created a situation for her. But she's a great agent. She's really good to work with. But oh, sorry, we're here to protect your client. We're here to protect you. And that's what we do. And so, you know, Linda runs a whole transaction management platform, but for other brokers too. But, you know, we're sending it, you know. And so, you know, we ask the question up front, you know, of our agent, yeah, are you okay with us, you know, sending it per the contract? And if they respond yes, then we do. Okay. So Nadine, good question. All right. Next page. You all ask really good questions. The good news is we don't have a whole lot left to cover, but I do have a couple of forms I want to show you. So I know I'm supposed to go until what, 2:15. So I should be okay. Expiration of the offer. So some of you have been reading ahead, obviously. Let's talk about that. Okay. Okay. So expiration of the offer. This offer shall be deemed revoked, and the deposit, if any, returned to the buyer. Remember, it's an offer. There's no contract. So we're going to assume that because there's no contract, that all bets are off at a certain point, right? Okay, so it shall be deemed revoked, and the deposit, if any, shall be returned to the buyer if there is a deposit. Okay, if the buyer never gave the deposit, which they shouldn't have, right? Paragraph 3A1 says the buyer will take care of getting the deposit where it needs to go, unless the offer is signed by the seller and a copy. And by the way, pay no attention to the uppercase C. We've been trying to get that fixed for decades, but it just doesn't seem to happen. Of the signed offer is personally received by the buyer, or if you put your name in there, I don't know about that, but if you put your name in, ours says none other. Okay, so personally received by the buyer, personally received. Okay, who is authorized, or you who is authorized to receive it, or their sister or their brother, not your sister, your brother. Okay, by 5 p.m. on the 3rd day after this offer is signed by the buyer. Okay, so in other words, if the seller doesn't sign this offer within that period of time, then it's over. Okay, why? Because otherwise we might be creating an option. It might be an option agreement, and we don't do option agreements. We did a lot of them up until the early 80s. I wouldn't do one today on a bet, folks. I mean, I've got attorneys out there. There's some brilliant attorneys out there, 4 or 5 page option agreements, and I'm going to do it in a contract? I don't think so, okay? Now, there's some things that we can do if they don't get to it on time, but let's talk about that. So 3 days, or by, and ours always, we never give them. So like right now, what time is it? It's 2 o'clock. So it's 2 o'clock. If I write an offer for a buyer today at 2 o'clock, I want acceptance by tomorrow morning at 9. unless I'm going to present my offer in person. I'd rather present my offer in person. In this technology day and age, I don't care what the listing agent says. I have a right to do it. The MLS says I can present my offers in person unless the listing agent has something in writing from the seller that says no, and they don't have it. They never have it, okay? Or it even says in the listing agreement that they allow it, okay? So they're not going to have it. I'd rather present my offer in person. If so, this is going to say upon presentation. All right, which means, Mr. and Mrs. Seller, I have a right to be here to present my offer. Here it is. I do not have a right to be here during your negotiations with your agent over a counteroffer or whatever. But the minute I walk out of this room, it's over. Follow me? Upon presentation, it's over. I have to do that, right? Because my buyer can still resuscitate it, but I have to make it so that it's over when I leave the room. They either accept my offer or what? They're either going to accept it or they're going to write a counteroffer. And if they write a counteroffer, then the time periods don't apply, right? Don't worry about it. If you're writing an offer and you give the seller 3 days, they made a decision at the time of the listing to sell the property, didn't they? Okay. What do they have to think about, right? The price? That's the only thing, right? What else? Okay. So that the listing agent can call all their buddies. I don't know. And hey, I got this offer, and the seller's looking at taking it, but they got 3 days. You got anybody right for more? Yeah, I don't know. I don't know what people do, what they think. And I'm saying that, I'm not saying that, I've sat on enough panels where I'm going like, are you kidding me? Okay. So, all right. So that being said, I don't put my name in there. And by the way, I don't give them a lot of time. If I'm writing it today at 2, I think you've got plenty of time to respond to me by 9 a.m. I think that's too much time, right? Okay. Seller wants to sleep over it. Well, maybe my buyer wants to sleep over it again too. You know what? Forget it. Let's just back up. I'm going to tell my buyer to think about it, and maybe we don't want this house. Okay. All right. Okay. So anyway, I do put a time period in there. I'm very specific about that. I'm very thorough. I'm very detailed that you have till this time. Otherwise, the seller no longer has the ability to create a contract between themselves and the buyer. But remember, once the seller writes a counteroffer, it's a rejection of the offer. That's right out of law school. It's a rejection of the offer, which means you can't go, just kidding. It's over. So the minute the seller writes the counteroffer, all the time, it doesn't matter. I mean, they could be writing the counteroffer at 2:30, and it isn't going to matter because the time period doesn't matter anymore because the seller can no longer commit the buyer to their offer. Okay? Because now the seller becomes the offeror. We switch roles. The seller becomes the offeror, and my buyer becomes the offeree. And now the seller gives my buyer a period of time to decide if they want, to create a contract between the buyer and the seller. All right? Don't give people a lot of time. I think 3 days is abusive. I don't know, where that came from. I'm sure there was some logic someplace, but I just never did it. I mean, do you want to sell your house? And you know what, folks, 3 days, I think is just too much time. There's just too many things that can go on. In the meantime, my buyer's saying, well, they didn't sign it yet. Let's go off and look at other places. They're calling me every 20 minutes. Did they sign it yet? No. Okay. Well, maybe they don't mean to sign it. Okay. I guess maybe not. I don't know. Let's go find something else. Okay. And then guess what? Then now your buyer's going to have a problem because seller accepts it, 10 minutes before the deadline, and they've already written an offer and accepted another. The buyer's already written another offer and accepted another property. And now maybe I'm committed to 2 properties. I don't want that. Okay. But again, remember, the minute the seller writes the counter offer, these time periods don't matter anyway. The whole role reverses, time periods now go back onto the other party. Okay. That is a very important concept. I'm not going to say it law. I'm going to say it practice, but it is a very important concept, and you need to understand it. Okay. All right. Okay. And again, I'll go over it with you whenever. I just got to watch my clock. Okay. On such and such a date, please. Okay. You do whatever you want to do, and do whatever your broker tells you to do. I wouldn't accept the 5 p.m. on the 3rd business day. I'm not going to do it. I never, ever give them more than 24 hours, ever. I mean, okay. All right. Everybody good? Next paragraph. Let's talk about my RCSDB. Yes, that form did change. Okay, so we have changed that form. I'm going to pull that one up for you here because I want you to see it. Here's my RCSDB, and it again identifies what the subject matter is up at the top. So-and-so is addressed as the buyer, okay? And then I'm not gonna, I mean, this isn't a forms class. Well, it's an RPA class, but it's not all this. A trust, please put in the name of the trust, including the date, if any, okay? It's an entity, either a corporation, a limited liability company, a partnership, or another. Authorizing manager, the documentation is or is not attached. Please check the box. Please be thorough on this, okay? You know, if you miss something, this is not intended to scare anybody, but if you miss something, people are going to be looking for that as a way to get out of their deal. So just make sure you're thorough about it. Make sure if you're newer in the business, talk to your broker. Say, am I doing this right? You know, your broker should tell you that. Your broker's responsible for you. They have a duty to supervise. It's 10177H, I think, right? And duty to Business and Professions Code. They have a duty to supervise your activities. So listen, contact your broker. Say, hey, you know what? Should I be doing this? Okay. All right. So my RCSD. So remember that I only have two different kinds of people. I either have, and this is a beautiful thing, right? I either have a natural person, somebody that bleeds, okay, natural person, or I have a non-natural person, which is any of these things, okay? All right, so it's interesting that they have LLC in there. So an LLC can definitely buy property, not a problem, but you know that an LLC can't get a real estate license. State of California won't issue a real estate license to an LLC, okay? All right, Trivia Pursuit, take it, leave it, do whatever. Power of attorney. Remember, this is not the power of attorney. This says that someone has already done the power of attorney, okay? And it's dated on such a date, okay? Power of attorney must have already been executed before you issue this form. Don't say, well, we're creating the power of attorney. No, then you don't have power of attorney. I need to be able to produce the proof. And if you haven't, it's like the LLC. Well, we're creating the LLC. How many of us know people that have been creating an LLC for years, right? Okay, all right. Estate, conservatorship, guardianship. You know what? There's going to be a superior court case number. If they don't have it, they're probably not one of those things. So, you know, that means, okay, let's talk about what it is. Maybe you think you have something that you don't actually have, okay? So then the buyer signs it, and then by the buyer, and then they print the representative name. Okay, you have two places for two, obviously, two signatures. Make sure you put in the date, make sure you put in the title, okay? All right, and then down here, I've got my acknowledgement of receipt by other party. This is one of the things that changed. So now the other side knows whether it's the seller or the vendor or the landlord knows that you know, who that they got a copy of it that says this person's authorized to sign on behalf of this entity. Okay, and so again, I think I'm going to want to have proof. Okay, but I need proof in all things, right? I'm the doubting Thomas. Okay, a little biblical there for you. At the time of buyer representation agreement, we definitely got this in our file, right? Because we won't work with you without one. So you know, all of our buyers sign buyer representation agreements. We just don't. We don't have time, right? Anybody have too much time? Okay, so all right, that's enough of that. Okay, let's go back to my language. So my date, the buyer, the buyer puts the date. So if you're having it signed wet, please have the buyer put the date. Don't you electronically put it in there. I want the same ink. So remember, we never predate, we never post-date documents. So I'm going to be looking for that. When I get the electronic signature, a little bit easier for me. Remember, you are 88% less like, I'm sorry, let me rephrase it, 88% more likely to forge a wet signature than you are an electronic signature. So when I get my electronic signature, as long as it's signed and then dated at the same time, I'm good, right? And they have all those codes in there and stuff like that. And so when I go into court and I go, yeah, that's the electronic signature. That's not the, you know, the double click by the agent because, you know, they didn't give them the agency disclosure until after it closed, you know, that kind of thing. Okay. So I have a place for two buyers. What happens if I have another buyer? What happens if I have 3 or 4 or 5? And that happens. Okay. So remember, we're not talking about an RCSD. We're talking about, you know, 3 brothers, or we're talking about 3 sisters, or we're talking about 4 or 5 people getting together buying something and they have not created an entity. Then I need my ASA form, which is my additional signature addendum. Okay. So let's pull up that form and take a look at that. And this is my ASA, my additional signature addendum. So again, remember, this is not an assignment. okay? And it's not intended to add parties after the contract. You know, you have other things that you need to be doing to do that. This says at the time of my offer or at the time of my listing agreement, I had more than 2 parties. Now I'm going to tell you this other little thing that says it really doesn't matter if you have their names printed on the contracts or not. It matters that they signed it. Okay, so, you know, that's why I do like the form and why we use the form. You see the recitals at the top, the linking part that I'm looking for. Okay, and I do want to make sure that I have the form, because when it comes to liquidated damages, I'm going to have all 3 of them initial. I know there's only spaces for 2, but I'm going to put a third right next to it. It's obvious. Or if there's 4, I'm going to have 1, 2, 3, 4 all on the contract. I'm not having anybody come back to me later on and saying, well, I didn't want liquidated damages to apply, okay? Or I did want it and I didn't sign it, or one of the 4 didn't sign it and now I got a problem, okay? And then down here, it even says down here that if only initial following if the document contains arbitration liquidated damages, which has been initialed by 1 or more of the parties. And so, yeah, I agree to it, I don't agree to it, that's all. And that's why I like that form. That's why I like that form, and I use the form, but then I'm still going to have on the purchase agreement at least, and on all the disclosures, I'm going to have everybody sign it. Okay, I want them all to sign it, and you know what? We're all adults, and let's you know how to use your electronic signature platform. You can add them to it, and let's go. Okay, all right. And so that's pretty much how all that works. Thank you all for being here, and take care for now.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.